Firstly, it's important for me to say that I fully support women's reproductive rights. I think we generally get the balance right here in the UK, and protecting this is a hill I will die on. But I'm disturbed by new clause 1 and new clause 20, which decriminalise abortion up to birth. If this becomes law, fully developed babies up to term could be aborted by a woman with no consequences. The reason we criminalise late-term abortion is not about punishment, it's about protection. By providing a deterrent to such actions, we protect women. We protect them from trying to perform an abortion at home that is unsafe for them. We protect them from coercive partners and family members who may push them to end late-term pregnancies. If we want to protect women from knowingly or unknowingly acquiring abortion pills after 24 weeks of pregnancy and inducing an abortion at home, we must put an end to this situation where these pills can be acquired without a face-to-face consultation where gestational age verification by medical professionals can take place. These are dangerous drugs if not used in the right way, as we saw when Stuart Warby spiked a pregnant woman's drink with them, resulting in the miscarriage of her 15-week-old baby. Make no mistake, the pills by post scheme enabled this evil man and his female accomplice to commit this crime. Criminalisation of abortion after 24 weeks isn't the problem. The pills by post scheme is. If new clause 1 passes whilst the pills by post scheme remains in place, here's what will happen. More women will attempt late-term abortions at home using abortion pills acquired over the phone. Some of them will be harmed. Many of these women won't have realised that they're actually going to deliver something that looks like a baby, not just some blood clots. That is going to cause huge trauma for them. Many of them won't have genuinely realised how far along they are due to implantation bleeding, being mistaken for their last period. And on top of all of this, some of these babies will be alive on delivery. What we need to do in this place is to get away from this terrible habit of only considering issues through a middle-class lens. What about women that have been sexually exploited and trafficked? What about teenage girls that don't want their parents to find out they're pregnant?
I believe that both lives matter in every pregnancy, both the mum's life and the child's life. Often, abortion is framed as a choice between the rights of the mother and of the child. I reject that framing, but today we're considering 2 amendments, NC 1 and 20, that would be bad for both women and unborn children, and 1 amendment, NC 106, that would protect both women and unborn babies who are old enough to survive outside of the womb. In the last Parliament, I, along with a number of colleagues, warned that the pills by post scheme for at-home abortions would cause an increase in medical complications, dangerous late abortions and coerced abortions. Sadly, these warnings have become a reality. A study based on a Freedom of Information request to NHS trusts found that more than 10,000 women who took at least 1 abortion pill at home provided by the NHS in 2020 needed hospital treatment for complications, equivalent to more than 1 in 17 women, or 20 per day. Last December, Stuart Warby was jailed after using abortion pills obtained by a third party through the pills by post scheme to induce an abortion of a pregnant woman against her knowledge or will. Such cases could have been prevented if abortion providers had not pushed in the face of warnings about precisely such incidents for the removal of in-person appointments where a woman's identity and gestational age could be accurately verified and any health risks assessed. It is this issue of an accurate gestational age that has indirectly led to the amendments before us today. Abortion providers have themselves conceded, and I quote Jonathan Lord, former medical director for Mary Stopes, that until recently only 3 women had ever been on trial over the past 160 years for illegal abortions. Since then, there has been an increase in investigation and prosecutions, albeit a small number, compared to the 250,000 abortions we now have every year in the United Kingdom. This small rise in prosecutions has been caused by the pills by post scheme, which has enabled women, either because they miscalculate their own gestational age or dishonestly to obtain abortion pills beyond the 10-week limit when at-home abortions are legal and considered safe for women, and even beyond our 24-week time limit for abortions. Tragically, this has led to viable babies' lives being ended. So what is the answer? Well, Madam Deputy Speaker, I suggest it can be to make it can't be to make things worse by decriminalising abortion. This would be bad for women and unborn lives, removing the legal deterrent against dangerous late-term unsupervised abortions that would put women at risk as well as babies even long after they're viable in the womb. This would render our already very late time limit redundant in a context where pills can be obtained without any reliable in-person gestational age check.
We are being asked to rewrite a profound boundary in British law that protects the unborn child with 2 hours of debate on a Tuesday afternoon. That is not responsible lawmaking, it is procedural ambush. It is telling that not even the promoters in this House of decriminalisation can agree on the form it should take. That ought to make each one of us pause, because it speaks to the challenge of moving beyond principle to real-world application. It is worth us recalling previous efforts to amend bills in this way and their consequences. The temporary pills by post scheme brought in during the crisis of the pandemic was made permanent by amendment hooked with little notice onto an unrelated bill. And what have we seen since? Women accessing pills under false names and gestational dates, taking them far beyond the recommended 10-week limit, viable babies lost in late-term abortions carried out. This is not women's health care, it is legal and medical failure. I'm afraid there's simply not enough time. And that failure is now being used to justify the loosening of abortion laws still further due to a recent uptick in cases of women being investigated. It is not extremist to want protections for viable babies. It is not anti-women to say that coercion or dangerous self-medication should not be outside the reach of the law. We also see the argument made that this is solely a women's health issue and nobody but she should have a say over what happens to her body. But that is to ignore a very inconvenient truth that has always stalked the abortion debate. This is not about one body. There are two bodies involved. Like it or not, this House has a duty to consider the rights of a woman against the safety and morality of aborting the unborn viable child without consequence. It is not extreme or anti-women to say that a baby matters too. I accept that NC1 does not decriminalise a doctor or third party carrying out an abortion outside existing time limits, but let's step back and ask why we have criminal law at all. It is not simply to punish, but to deter.
Madam Deputy Speaker, I've heard it said that no woman would induce an abortion after 24 weeks, but we cannot introduce such a profound change to abortion law on a simple hope that no woman would take such a drastic step. If we remove the possibility of criminal prosecution for abortion post 24 weeks gestation, then it is a certainty that some women will take this drastic step if there are no sanctions, no wider consequences. I'm afraid I'm going to make some progress. In 2024, according to government statistics, there were 250,000 abortions. If only 1% of these abortions took place as late-term abortions, this would mean 2,500 late-term abortions per year. We also risk the rise once more of backstreet abortions. Imagine a scenario in which a woman knows that she can now not be prosecuted under the law for a late-term abortion, but for some reason wishes or is pressured into going ahead with one. Surely at this stage she's more likely to get hold of pills by post, which are not considered safe to take outside of a clinical context after 10 weeks, by pretending to be under the legal limit or undertake a dangerous procedure on herself or seek to procure an off-the-books abortion. I'll make progress. Madam Deputy Speaker, these amendments are seeking to address a perceived problem of police actions that were overzealous in a handful of cases by making a fundamental change to abortion law that will put more women at risk while also risking the lives of infant children. The choice for colleagues here is very clear, indeed stark, to approve the biggest change to abortion law in 58 years, whilst potentially, I believe, making things worse for women and their unborn children, or solve the problem of criminal justice overreach by reinstating in-person appointments for abortion. Madam Deputy Speaker, I'll just finish with this. This is clearly a very, very difficult subject. I just feel that this is not the right way to go about such a divisive and emotive subject as an amendment onto it, but I'll leave that there. Thank you, Madam Deputy.
Views on abortion do not have to be absolutist. Being pro-choice is not incompatible to being pro-life when the fetus is at a stage of being inherently viable. Believing women should have the autonomy over their bodies does not negate the need for a system that safeguards women from physical and emotional harm. As we have heard, New Clause 1 would have the effect of ensuring a pregnant woman is not criminalised for accessing an abortion during her pregnancy. It would, however, retain the law as it stands for the provision of abortion within healthcare settings. Effectively, a woman in England and Wales would be able to legally abort an unborn child and do so at her own means at any moment prior to a natural birth. But a healthcare professional would be breaking the law if they tried to help her to do so outside the 24-week limit. So on one hand, abortion would be decriminalised for women, while on the other, restrictions on her ability to access the same procedure in a safe, controlled and supporting setting would remain. We must be careful not to create a law that has unintended and potentially harmful consequences, especially for those it is designed to help, especially when those likely to rely on it are likely to already be in a state of stress or distress. And new Clause 1 raises many questions. Is it tenable to legalise all but full-term abortions in England and Wales, but not other parts of the UK? What would be the legal implications should a woman in Gretna travel 10 miles across the border to Carlisle to carry out an abortion after the 24-week limit that is in place in Scotland? How do we monitor such abortions when, in line with the amendment, they would be occurring outside a healthcare setting? How do we ensure that a mother's health is protected and supported, both physical and mental health? And what happens to the fetus once delivered should the abortion be outside a healthcare setting?
New Clause 20 would de facto have the effect of fully decriminalising abortion up to full term, both for women and abortion providers. Now, you don't need just to take my word for it. It's not often that you'll hear me agree with the British Pregnancy Advisory Service, the UK's leading abortion provider. But its own assessment of New Clause 20 concludes that it would, quote, largely render the Abortion Act of 1967 obsolete and, quote, create a regulatory lacuna around abortion provision and access. But there is one additional angle members need to be aware of here. Regarding New Clause 20, the legal opinion finds that the effect of the amendment is that a woman who terminated her pregnancy solely on the basis that she believed the child to be female would face no criminal sanction in connection with that reason or at all. Similarly, on New Clause 1, the opinion confirms it would, quote, not be illegal for a woman to carry out her own abortion at home solely on the basis that the fetus is female. So these amendments are not pro-woman. They would introduce sex-selective abortion. Sex-selective abortion is already happening in this country. Back in 2012, the Telegraph investigation found that doctors at UK clinics were agreeing to terminate fetuses because they were either male or female. A BBC investigation in 2018 found non-invasive prenatal tests were being widely used to determine a baby's sex early in pregnancy, leading to pressure imposed on some women to have sex-selective abortions. This evidence led the Labour Party to urge a ban on such tests being used to determine the sex of babies in the womb. A Nuffield Council on Bioethics report similarly found several websites were privately offering tests to determine the sex of a baby, and the Council warned that the increasing prevalence of private testing may be encouraging sex-selective abortions. Passing New Clause 1 or New Clause 20 would likely make the situation worse. In conclusion, what we are faced here is an extreme set of amendments going way beyond what public dominion demands or way beyond what is happening in any other country in the world.
And I'm grateful for this opportunity to place on record my grave concerns about this hurried attempt to significantly alter our nation's abortion laws. It is my view that in doing so, we risk creating a series of unintended consequences which could endanger women rather than protect and empower them. We need more time. Today's debate is not a pro-choice versus pro-life debate. We already have the most inclusive abortion laws in Europe. Medical abortion available up to 24 weeks is double the European average, and obviously we have the option for full-term abortion on medical grounds. Instead, today's debate is about ensuring that legislation as significant as this, seeking to introduce a wholesale change to our abortion laws affecting England, Scotland and Wales, is not rushed through without the chance for significant scrutiny. And indeed, 90 minutes of backbench debate doesn't cut it, in my opinion. We should, of course, treat women seeking an abortion with compassion and dignity. That goes without saying. And as a councillor on Plymouth City Council, I chaired the Commission on Violence Against Women and Girls. Defending the voiceless is my guiding principle principle in politics, and it is with these women and unborn babies in mind that I make this speech. As over 1,000 medical professionals have shared in an open letter cited in the Daily Telegraph today, if offences that make it illegal for a woman to administer her own abortion at any gestation were repealed, such abortions would de facto become possible up to birth for any reason, including abortions for sex-selective purposes, as women could mistakenly, knowingly or under coercion mislead abortion providers about their gestational age. If either of these amendments were to become law, it would also likely lead to serious risks to women's health because of the dangers involved with self-administered late abortions. They continue, quite aside from the increased number of viable babies' lives being ended beyond the 24-week time limit, there would be a significant increase in such complications if the amendments NC1 and NC20 were to pass, as they would remove any legal deterrent against women administering their own abortions late in pregnancy. The current law permits flexibility and compassion where necessary, but for these reasons, we believe a legal deterrent remains important. Now, many supporters of New Clause 1 and New Clause 20 claim that the 24-week time limit for abortions would not change, but in my view, this is misleading. Any time limit is meaningless if abortions are legalised all the way up to birth for any reason without a legal deterrent. Once decriminalisation takes place, it is my concern that further steps will be taken to expand abortion time limits, and indeed many of the campaigners who've been mentioned this afternoon are on record for saying as much. Public opinion and professional advice indeed is clear. Polling undertaken by Comres reveals that only 1% of the public support introducing abortion up to birth. 70% of women would like to see a reduction in the time limit from 24 weeks to 20 weeks or less, still well above many of our European neighbours. And 89% of the population opposes sex-selective abortions, which amendments NC1 and 20 would allow. No, I'm not going to. I'm going to make some progress. Those championing NC1 claim that the amendment is needed to stop arrests, long investigations and prosecutions of women. However, it is important to highlight that prosecutions under sections 58 and 59 of the Offence Against a Person Act almost always relate to males inducing or coercing women into abortions. By decriminalising women, you also, by implication, stop the opportunity to prosecute abusive or coercive males. To be prosecuted for aiding and abetting abortion, there needs to have been a case to answer in the first place.